Good afternoon, everyone. My name is Jai Vargas. I'm founder and CEO of the Latinista. Thank you so much for being here. We'd love to welcome you to today's webinar. It's going to be focused on wills, trusts, and estates. And now I'd love to welcome our speaker for the day. She actually used to work with me in a previous lifetime. She is an attorney, and she's going to tell us all about wills, trusts, and estates. And if you have absolutely no idea what those mean, you are in the right place. We're going to make this a very conversational discussion. And so any question that you may have for Lillie, we want you to know that it's never a silly question.
Right.
Lillie is an attorney, and she's going to be speaking to us about everything that you'll need to get all of your papers in order. And so without further ado, Lillie is going to introduce a little bit about herself, the type of work that she does, and she's going to go through a few slides of the work we're going to talk about, and then we're going to be open to Q&A. Throughout this discussion, we would love for you to use the chat box to be able to interact with us. So without further ado, Lillie, introduce yourself and the type of work you do. Thank you for being here.
Thank you, Jai. I love being here. Hello, Latinista members and friends and family of the Latinista. It's a big deal that you guys are here. It's a big deal because before we're anything else, we are human beings that are living through a real life pandemic. And so I commend all of you for still moving forward, doing the best that you can, still tuning into webinars like this to get new information, because during a time like this, I think it's relatively easy for people to put their head in the sand and say, wake me when this is all over. But the fact that you all are here is just absolutely fantastic. I'm so proud of all of you for being here. And my job really is to give you as much information as possible. Well, as much useful information as possible without overwhelming you. So I want you to be able to walk away with a couple of basics today. What is an estate plan? Whether you need an estate plan, and how you can get an estate plan for yourself or for your loved one. Some of you may be tuning in and saying, hey, I'm all set, but I need this information from my mom or from my aunt or from my godparent, whomever it is. We're all in need of estate planning to a certain extent. And so if you can walk away with those three things, I think you're going to be in great shape. As Jai said, I am an estate and business planning attorney. I've been doing this work for approximately 13 years. This summer will actually be 13 years. I love what I do. I love what I do because twofold. One, I find it to genuinely be interesting. And then two, I find it to be really empowering to educate people about estate planning, because most people just don't know how powerful they really are. And they don't know that they have a lot of control with respect to their estate. It doesn't just have to happen haphazardly. I say that 3 times fast, which clearly I can't. So I love encouraging people and empowering people with this information, because you have a lot of power just at your fingertips that you're not aware of. And so today's session is supposed to make you kind of sit up in your chair straight a little bit more and realize, yeah, I do have the power here. So I'll take us through some basics. I will share my screen with everyone, and feel free to ask any questions along the way in the chat room. I will share my slides right now, and you all let me know. Well, Jai, you can chime in and let me know if everyone can see it.
Yes, it's perfect. It's planning looks good on you.
Yes, thank you. And the reason I love this topic is because my clients tend to be a lot of women. They are women age, I would say 35 to 55. And they're hustling, they're building their career. They're like Jai, building these beautiful businesses, and they're looking good and they're sounding good, and they have the degrees and they have the money, and they forget to do their estate plan. If you build up all of this wealth, if you build up all of this cachet, if you go and purchase all of these assets and you don't have a fence around it, then you really exposed yourself, and everything that you've built could really disappear relatively quickly. And so my job is, again, to share with you how it matters to you and how you can get it done so that you can feel empowered. So just like you're bank account looks good on you, and that favorite pair of knee-high boots looks good on you, or that jacket looks good on you, or your condo looks good on you, planning looks good on you as well. So why are we creating an estate plan? One, it's to organize your goals. They keep telling me, you know, we can't speak to the dead unless you have that gift. I don't have that gift. So because we don't have that gift, we need to organize your plan, which means it needs to be something in writing so that the people left behind know what your intentions were. Secondly, control the narrative. And I'll explain a little bit more about what that means, because if you don't have a plan, the state that you reside in will give you a plan. And it's a generic plan that the state will give to everyone who happens to pass away without a will. But if you have your own document, then you get to control the distribution of your assets, the how, when, who, and where. And then it also allows you to manage your money. Again, to my example before, I'm in downtown Brooklyn. I just feel the hustle. Well, I don't feel the hustle energy today, but up until end of February, I felt the hustle energy, and everyone's creating and everyone's building and everyone's saving, but we don't have a plan to manage what happens to the money when we're not here. So that's really another reason as to why we create the plan. So let's start with just the basic plan. The estate planning can be as big or as small as you want it to be. So if you have questions or concerns that extend beyond the basics of this presentation, that's fantastic. Feel free to reach out to me and we can have a one-on-one. At the end of the presentation, I'll share my contact information for those who want a conversation. So there are a couple of basic documents: the will, the power of attorney, the healthcare proxy, and the living will. Those are the 4 basic documents, I think, in my professional opinion, that everyone should have. So let's start with the will. What is the purpose of the will? The will is supposed to direct the assets and let them know where to go. Think of it as a safety net. You have a lot of things in your house that know where to go. For instance, your house probably knows where to go because it has a successor owner on it, or there's a co-owner on the property. Your insurance policies, life insurance, retirement plans, 401ks, things of that nature, those know where to go because they pass by contract. So the beneficiary that's listed on those types of documents automatically know where to go. But your other assets, things that don't pass by law, the things that do not pass by contract, they're just hanging out, waiting for someone to direct them to the right place to go. And so the purpose of the will is to come in and kind of act like a crossing guard. I know some of us, has been a while since we've been in a middle area, but remember when your crossing guard was there and said, hey, you can't go there, you have to go here, you can go now, you can go later. That's what the will is doing. It's acting as your security guard, your crossing guard, whatever guard you need to imagine that directs how your assets are going to go. Now, the common question I get from people is, I don't have a lot of assets. Do I need a will? And to that I say, you probably still need a will, because let's make a clear distinction between estate planning and estate tax planning. Estate tax planning is for the wealthy, and wealthy keeps changing, and wealthy varies from state to the federal government. Right now in New York, you're considered wealthy if when you add all of your assets, you're worth more than 11.5 million. If you find yourself in that situation, 1, congratulations. 2, then you need to engage in estate tax planning. That's a whole different animal that we're dealing with. But for those who are not up to the 11.58 threshold, then you still need to engage in estate planning. Estate planning is for everyone, and estate tax planning are for the persons who exceed that 11.58. It's 11.58 in New York. In Connecticut, it's 3 million. In Massachusetts, it's 1 million. So the definition and the numbers vary by state. We could have a conversation about the state that you're in. But here in New York, wealthy is considered 11.58. Estate planning is for everyone else. So if you care about who receives your assets, when they receive, and how they receive it, then estate planning is for you. Do not become consumed with the value of your assets. What's most important is you have an asset that needs to know where to go when you are not here. That includes my small business owners. I see you guys out there. You're building something amazing. You're building something beautiful. You just started an LLC or you just opened an S Corp. That's fantastic. What happens to that business when you are not here, especially if you are running it by yourself, meaning you are the sole owner of that entity. So if you care who receives your assets, how they receive your assets, and when they receive your assets, you need estate planning regardless of the value of that asset. That's the first reason we have a will. Second reason, it provides guardianship. Some of us on the line have minor children, meaning children under the age of 18. If something were to happen to you or you and your partner simultaneously, who cares for your minor children? They need to be in someone's house. They need to have money set aside for them so that that other person can raise them. Who is that person going to be? And I just want to remind everyone that godparents status is not a legal designation. I know you have godparents. I know you had a beautiful christening and there was a great get together after the church, but that is not a legal designation. The court doesn't recognize that. And the court doesn't automatically send your children to go live with their grandparents or with your siblings. There needs to be something in writing that dictates who's going to care for that child. And I'll tell you this, a lot of times my clients get hung up here because it's very challenging for them to decide who's going to be able to raise my child in the way that I would, in a way that's similar to how I would raise my child. And because they get stuck, they don't do anything. And the main reason they get stuck is they can't figure out who should raise the child because they're thinking this person who raises my child is not good with money, and I don't know if I want to give them the money to raise my child. I always remind people you can have a personal guardian. That's the person that your child is going to live with. They're physically going to raise your child. And then you can have a financial guardian. That's the person who is going to manage the money that will be used to raise your child. So if you feel like your brother would be fantastic loving and raising your daughter as his own, but your best friend is better with money, you can separate those responsibilities. The personal guardian and the financial guardian do not have to be the same person. And so if that's holding you up, rest assured that you have options. Lastly, the will controls probate. There's another myth that if I have a will, I skip probate. You don't skip probate. Everybody needs to go through probate. It's just like everybody needs to pay taxes. Mostly everyone. Everyone needs to go through probate. The issue is the will allows you to control probate so it's faster, smoother, and costs less. Because remember earlier I said, if you don't have a will, then the state that you reside in will give you a general will. It's called passing intestate. Intestate is what happens when you pass away and you don't have a will. So then the court essentially comes in and says, oh, I see that Heather passed away without a will. We're just going to give her a will and it'll be a generic form. It's usually something that says give everything to your spouse. Or if you have children, it'll split between your children and your spouse. Or if you don't have a spouse and you don't have children, it'll just start looking for the next of kin. They'll look for your parents. They'll look for your siblings. They'll look for your nieces and nephews and continue to go down the line. And if there's a rare situation where there are no living family members, then whatever is in your name will belong to the state at that time. So we want to control the probate process because we don't want the courts to come in and give us a generic will. Even if the court's will is pretty much the type of will you would have had for yourself anyway, you still want a will so that you can control the narrative and so you can make it easier for the persons who are left behind. I'll pause there if anyone has any questions.
No questions yet, but for some of those that don't know what probate is, can you explain that?
Thank you. Great question. So probate is the process of proving that your will is valid. whenever firstly, your will is a private document up until you pass away. So wherever you have it, that's where it is. It doesn't need to be filed with anyone. You're going to have one original copy, and your attorney will probably have a digital copy. So it's private until it's time to go to probate. Probate is the process of presenting the will to the court, and the court overlooks the will to make sure that it's valid. How do we know it's valid? Was it signed properly? Were there witnesses? Was it notarized properly? Is there any indication that would say that the person who created the will was not of their sound mind? Were they being coerced? Were they being bullied or taken advantage of? The people who are listed in the will, can the court find those people? The executor, meaning the person who is carrying out the instructions in the will, is that person in their sound mind? So it's a process of making sure that this will is actually valid and that it makes sense to be able to administer. So probate, that's why I said, great question, Jai. That's why I said no one skips the probate process, because all wills that go through the court have to be proven valid. But if you have your own will, it makes that process smoother. So you want a will so that you can make it easier for the people who are left behind. And when I say people left behind, I'm really speaking about the person who's going to manage your estate. So I should define some terms. When you create a will, that makes you the testator. When you choose someone to manage your will and probate and distribute all of your assets according to your instructions, that person is your executor. And then the beneficiaries are the people who receive something from your will. So let's make it a real life example. Let's say I want to create a will, and I look at that makes me the testator. And I look at all of the people in my life and I say, you know what? You know who I trust the most? I trust Dominique the most. I'm going to make Dominique my executor. Here's a little hint. Ask the person who you want as executor if they're willing to serve as executor. There's been times when people said, oh, I didn't know that so-and-so made me their executor. I don't think I really want to do all of that work. So whomever you choose, run it by them and make sure they feel like it's okay. So I've chosen Dominique to administer my will. That makes her the executor. And let's say I leave everything to my husband and my children, and that makes them the beneficiaries. So you have the testator who's you, who would create the will. Your executor is the person who follows the instructions, and your beneficiaries are the persons who receive the assets from your will.
Wonderful. Thank you.
Wonderful. Okay. So I have a quiz here. Lisa is 36 years old in a committed relationship, no kids. Does she need a will? Yes or no? You can put in the chat, and then Jai, you can tell me what the general consensus is.
Yeah, let's see. So far we have yes, heck yes. Yes, yes, and yes.
Oh, wonderful. I would say yes as well, especially if Lisa has property and she has or she has a business. So Lisa might be 36 years old, no, not in a committed relationship, doesn't have kids, but maybe she owns her own brownstone, her own condo, her own home. You need someone to come in and kind of figure out what's going to happen to the stuff that's in her home. She might have a timeshare somewhere. So it's just better safe than sorry to have a will. Lisa may only need a super simple will, nothing complicated, nothing expensive. But I think it's worthwhile to spend $500, $600, $700 on a will to make sure that you have a safety net for your assets when Lisa's not here. So good job. I agree with everyone's answer. Now, let's talk about a revocable trust. This is the second document that you may or may not need. And I say may or may not for a reason. The revocable trust is really good for those people who want to have long-term distributions, meaning you don't want to give something to someone outright You want to give it to them slowly over time. So back to my example. Let's say I have $100,000 that I'd love to leave my brother Jerry. If I left it in a will, as soon as the probate process is done, Jerry gets $100,000 done. He can take all of that money and buy a house, or he can take all of that money and go to Vegas. He can do whatever he wants to do with the money, because after the probate process is finished, it fully belongs to him. However, if I say, you know what, I don't think I want to give Jerry $100,000 all at once, he would probably go a little crazy. Let me give him $25,000 every year for 5 years. That way I can make sure that he doesn't waste it. If it's my desire to control how he gets it and to spread it out over time, that's when I would lean towards a revocable trust. So this is fantastic for family members who you feel like are not good with money and they should not get it all at once. This is good for family members that may have some type of substance abuse problem and you're afraid that if you gave them everything at once, it would really add to the problem. It's good if you are concerned about your family member's spouse, meaning, let's say I wanted to give this $100,000 to Jerry, but he's married to someone that I feel like may take advantage of the money, or he's in a marriage and I'm concerned that they may get a divorce. And because I gave him the $100,000 at the divorce, she might be able to have access to it. And in my mind, I'm thinking, well, that's a gift for my brother, not for my brother and his future ex-wife. So if those are my concerns, person with bad money habits, person who has the substance abuse, protected from creditors, protected from my beneficiaries' possible future ex-spouses, then that's when I would lean towards putting it in a revocable trust. A trust can last for a very long time, 100 years pretty much in the state of New York. So you can benefit your children, your children's children, your great-grandchildren. You can create a fantastic legacy using a trust. Whereas a will, you want to hurry that thing and close it up as soon as possible. You don't want probate to go on for years and years and years. You want to distribute your assets and move on. The other reason why a revocable trust may be good for you is it avoids probate. Remember I said we all go through probate? Well, the little asterisk next to that comment is except trusts. Trusts are considered a private document that do not go through the probate process. And I wish, honestly, I had a rational reason for why the court feels like they need to scrutinize a will, but they don't need to scrutinize a trust. But I don't have a really great reason. I'm just running with it and sharing the information with you all. Revocable trusts are seen as private documents that do not need to be scrutinized by the court. And so they get to skip the probate process. So, and which reminds me, the will is a public document. So that's why you guys ever notice when a celebrity passes away, everyone starts talking about their will, their will, their will. That's because when you pass away and your executor brings your will down to the courthouse, it becomes public. So if I wanted to, I could go down to the New York Surrogates Court. Technically, it's not open right now, but you know what I mean. I could go to the Surrogates Court, and if I have a name or a file number, I could pull up anybody's will. So there are some clients of mine who are uncomfortable with that because they don't want people to know who got what and how much or anything like that. So they're more likely to lean towards a trust so that they can keep their estate wishes private. I'll pause.
We have a couple of questions as well.
Yes, feel free.
Are there instances in New York where your assets automatically go to your spouse?
Great question. Your assets automatically go to your spouse if your spouse's name is on the asset. So the short answer is no, not really. There's nothing that automatically goes to your spouse. There are things that tend to go to your spouse because their names are on it. For instance, most of us have our spouses listed as the beneficiary of our retirement plans. That goes to your spouse, not because they're your spouse, but because you named them as the beneficiary. Or the same thing with your home. Most of us own our homes jointly with our spouses. So when one spouse dies, the other one automatically becomes the 100% owner. But again, that's because it was titled that way, not because they're entitled to it due to marriage. So there really isn't anything that automatically goes to your spouse. You have to be intentional about it. Well, the only thing that automatically goes to your spouse is custodianship of your children. So if you pass away and you're married, then your spouse will automatically become the full custodian of your child or the children that you guys share. But other than that, no. Great question.
And then we also have another one. It says, can you revise your will as needed?
Yes, great question. So the will can be changed at any time. And in fact, every 5 to 8 years, you should really dust that thing off and look at it to make sure it still says and does what you want it to do. Sometimes the executor that you named 5 years ago has passed away, or you no longer trust them. That's a time to change the document. Maybe you've gotten married or remarried, you've had kids, and none of those persons are mentioned inside of your will. That's a great time to go back and edit it. So a will can be changed and edited at any time. Same thing for a revocable trust. It can be changed at any time. These two documents only become permanent and irrevocable when you pass away.
Okay, one more. Does your credit card or equity loan debt automatically go to your spouse?
Great question. It does not automatically go to your spouse. So if I die today and I have $50,000 in debt, that's a debt against my estate. Unless my spouse is a co-signer of that debt belongs to me and my estate. So if I owe $50,000, that company is going to put a lien on my estate and ask the court for it to be paid first before any of the other assets can be distributed, because that creditor knows that once my executor distributes my stuff, there's no more money that that creditor can have access to. So let's say I have a $200,000 estate. When you add up, and by the way, your estate is everything that's in your name, regardless of where it's located. So if I have a condo in Brooklyn and a townhouse in the Poconos and a timeshare in Florida, and I have a business in New Jersey, and oh, me and my brother split this loft in Paris, anything anywhere in the world that has my name on it is part of my estate. So in my example, let's say we added all of those assets that I just listed and it's worth $200,000. That means my estate is $200,000, but I owe someone 50 grand. What they will do is they will come in and collect the 50 grand first before any of my assets are distributed. And then what's left, 150, that will then be distributed to the beneficiaries who are listed in my will. So the creditor gets their cut first of whatever's left in the estate, and then the rest gets distributed to the beneficiaries. Great question.
Awesome. We have two more questions, but we'll go back to your slides and then we'll come back.
Okay, wonderful. Okay, so we've spoken about the trust. Now, here's a quiz question. A revocable trust replaces a will, yes or no? I love this question because a lot of times people ask me, if I have a trust, do I need a will? And if I have a will, do I need a trust? So I'll throw it out to you all. If you have a revocable trust, does it replace a will? Yes or no?
That's a good question. We are getting some action in the chat room.
Okay.
Martha says no. Heather says no. Jasmine says no. I'm going to go with the team. I'm going to say no as well, but I honestly don't know.
Well, you chose the right team, Jai, because your team is right. The answer is no. I always like to say the will acts as a safety net. It catches the things that kind of slip through the cracks and don't know where to go. So even if you have a really great trust that directs your assets, there might be something that slips through the cracks and you want that safety net to catch it. That's one reason. The second reason is, remember, everyone has to go through probate. just because there are assets in the trust that skip probate doesn't mean you're not going through, or your estate is not going through the probate process. So the will, at the very least, should be used just to minimize the stress, the cost, and the hassle of the probate process. So I think you should have both the will and the trust. You don't need a trust, but if you have a trust, that doesn't negate the need for a will. Great job. You guys are 2 for 3. So power of attorney. This is the third document. Remember, there are a couple of basic documents. We started with the will, we moved to the revocable trust, and now we're at the power of attorney. The power of attorney is a legally binding document that gives someone the right to make financial and legal decisions on your behalf. This is basically, so the person who creates the power of attorney is the principal, and the person who you give the authority to make those decisions for you is your agent. Think of it as like your sports agent, right? LeBron has a sports agent. He doesn't go to every single meeting, right? He sends his agent as his representative. So same thing with the power of attorney. If you find yourself in a situation where you are incapacitated and you can't make financial decisions on your behalf, you can't make contractual or legal decisions on your behalf, or maybe you're not incapacitated. Maybe you're the type of person who says, you know what, 2 months out of the year, I backpack in Europe and don't want to be bothered by anyone, but I have a business, and the business, the show must go on. So you know what, I'll name so-and-so as my agent so that they can handle all of my business matters during those 2 months that I'm not here. So it's not only incapacity, it's just general direction to someone to act on your behalf as it relates to financial and legal matters. This is a very important document and a very powerful document, because let's say I say, Jai, I trust you implicitly. I want to make you my agent. I'm giving Jai that authority immediately. As soon as the documents are signed and witnessed and notarized, Jai technically has the power to go to my Chase account now, to my Bank of America account now. Now, I trust Jai, and she shouldn't do that. I really only want her to have access to my monies and my business when I become incapacitated, or if I become incapacitated. But technically, her power starts immediately. So you want to choose the right person for the job. And the good thing is, this is a revocable document. So just like you can change a will and you can change a revocable trust, you can also change a power of attorney. So I might name Jai as my agent today. In a few years, it no longer makes sense for her to be my agent. I have every right to cancel that power of attorney and name a new person as my agent. For whatever reason, I don't owe anyone explanations. I don't need to get any court approval. I can just make the changes. So it's an important document, and it's a powerful document because you want to choose wisely, and you want to choose someone who's going to be able to make those financial and legal decisions on your behalf. A lot of times people will say, ugh, that makes me a little uncomfortable. I don't know if I want to give so-and-so all of that power. To that, I'll say, we can add in some restrictions to make you comfortable. I don't want to add in too many restrictions to your document because it starts to negate the purpose of the document. But if you tell me, Lillie, I want my brother Adam to be the power of attorney, but I only want him to have access to this account, or I only want him to have access to this account up to a certain dollar amount, or I have 2 businesses and I only want Adam to be the agent for one business, not the other business. We can add in those types of restrictions. But again, I don't want to make too many restrictions because you're giving this person the power to act on your behalf in the event you're incapacitated. And if you ever become incapacitated and the document is too restrictive, then your agent is not really able to help you in the way that they're supposed to help you. So that's the power of attorney. Just for financial and just for legal, this person will step in as your agent and make decisions on your behalf. I'll pause there for questions. Okay, we will keep going here. Next document, healthcare proxy. Very similar to that of the power of attorney, except this is for medical decisions. So if you, let me say one. Let me go back to the healthcare proxy. I get this question a lot. Many people have asked me before, can't my spouse just automatically be my power of attorney? And the answer is no. Your spouse does not have a legal right to make financial decisions on your behalf. Your spouse doesn't have a legal right to go to Bank of America and say, hey, this is my wife's checking account. I want to have access to $500. Your spouse can't do that. So you need the power of attorney. Same thing for contractual or legal obligations. Your spouse can't march into the business and say, oh, my better half is not here, but that's okay. I'll sign these contracts on their behalf. No, no, no. So if you want your spouse to have that authority, you have to go the extra mile and make them your agent. Same thing for the healthcare proxy. Your spouse, now in many hospital institutions, the doctors may defer to the spouse in the event that you're incapacitated. So let's use me as an example. Let's say I get into a car accident. I'm going to survive, generally speaking, but I'm hurt really badly right now and I'm in a coma. Persons in comas aren't alert, so they can't make decisions on their behalf. The doctor will need to consult with someone to say, hey, these are Lillie's 3 options. This is surgery option A. This is surgery option B. There needs to be someone by your bedside that can act on your behalf. That person is also your agent in that situation. And that authority doesn't automatically go to your spouse. There may be some hospitals that will defer to a spouse to a certain extent. But remember that hospitals, even though they're beautiful, caring institutions that do a lot of good, especially during a time like this, and they are also businesses. And as a business, they need to protect themselves from liability. So a business that just says, a business that defers to a spouse without having a healthcare proxy is liable to be sued in the future by some disgruntled family member. So if you want your spouse to have that right, you need to go the extra mile and set up a healthcare proxy for your spouse as well. There are institutions that have their own healthcare proxy. So if your doctor has his or her own proxy, you can go ahead and sign that. But remember that proxy is only good for that doctor or for that hospital. It's not good outside of that situation. It's not good outside of that state. So having your own healthcare proxy that essentially can go with you wherever you go, relatively speaking, is going to be more beneficial than signing the contract at your doctor's office, because then you need to go to your primary care physician, your dentist, your surgeon, your internal medicine expert. You'd have to hop around to all of your doctors to sign their healthcare proxy versus having one of your own. I have a question here in the chat. What happens if you want to leave your assets to an organization after you die? What is the process there? Fantastic question. Same process as a will. So if you have a charitable organization or an alma mater that you'd like to be a benefactor of, you would just name that organization in your will. So again, back to my example where I own all of these assets across the world and they total $200,000. In my will, I could say $50,000 to Jerry, $50,000 to Rodney, $50,000 to my spouse, and $50,000 to the Down Syndrome Society of Brooklyn, New York. And the organization will receive that tax-free, and it just goes quickly through the will. Great question. Another question. Can power of attorney supersede the executor, or are they different? Great question. Okay, they are different. The power of attorney and the healthcare proxy are documents that are only powerful while you are alive. You are the principal. So your agent can only be your agent while you are alive. Even if you're incapacitated, in a coma or anything like that, they're only your agent while you're alive. That contract becomes null and void at your passing. And then at your passing, that's when your executor comes into power. So you have multiple layers of protection here. And by the way, these people that I'm mentioning, they could all be the same person. Your spouse can be your healthcare agent, your power of attorney agent, and your executor and your trustee. That's fine, but there are levels. So your power of attorney acts first while you're alive, and then after you've passed away, your executor comes into power. Another question I'm seeing here, thank you for that question, by the way. Another question I'm seeing here is, are there any limitations on what assets we can put in a trust? Fantastic question, Heather. No, there really aren't any limitations. And I say there really aren't because it just depends upon what your vision is for that particular asset. And it also depends upon the value of that asset. If you're wealthy and you have assets that exceed that threshold that I mentioned earlier, the 11.58 million in New York, I would lean more towards a trust than a will. That's when we're into estate tax planning and we need a different type of trust for that situation. But outside of that situation, you can put just about anything you want in your will, So if you want your house to pass through your will, you can. If you want your personal belongings, your checking account, things of that nature. But I'll give you a little tip. Your assets will pass in one of three ways. They will pass by law, by contract, or by estate planning or probate. And that's the order of operations. That's the order of power. So the assets that pass by law trump the assets that pass by contract. And the assets that pass because my husband is scheduled to receive it through law, the law trumps the will. Another example is, let's say my husband is the beneficiary of my life insurance policy, but somewhere down the line, maybe before I even got married, I put something in the will that said my mom gets the life insurance death benefit. Well, sorry, mom, contracts trump wills. So assets will either pass by law, contract, or will. So Heather, thank you so much for your question because that reminded me that I should share that. So no limitations on what you can put in a trust or assets in. Oh, you asked me for a trust. Sorry. Are there any limitations on what assets we can put in a trust? No. That's the question you asked me. I thought it said will. No limitations. I'm trying to think off the top of my head. No limitations. You can put anything in a trust. There are things that I advise you do not put in a trust. For instance, I would move my retirement plan to a trust because when you change ownership on your 401k or any retirement plan, it causes all of the gain in that plan to be taxed at that time. You don't want that. So outside of those tax consequences, you can put anything you want inside of a trust. So healthcare proxy, same thing as the power of attorney, but you're giving this person the authority to make medical decisions on your behalf. You should have one so that you need one for every state that you're in, meaning if you move to New Jersey, but you have a healthcare proxy from New York, that likely will not work in New Jersey. Same thing with the power of attorney. Same thing with the will. So when you move, that's another life moment for you to update your documents because different states have different rules. Their wills look differently. The language in the wills are a little different. So you should make those changes if that were to happen. And I'm licensed in New York, New Jersey, and DC. So I have clients who started in New Jersey and came to New York and vice versa. And I was able to help them with all of their planning needs. Living will is our last document here. It's more for end of life instructions, meaning if the doctor has said that you will not recover, maybe there's been a stroke or a brain aneurysm and you're on life support or you're brain dead, and the doctor says, listen, I don't think your family member is going to ever recover. I don't think they're ever going to be conscious. Then that's the opportunity for the agent to follow the instructions in the living will. The living will basically say, if the doctor says I have no chance or very little chance of recovery, then stop life-sustaining measures. That might be anything from stop feeding me, remove the tubes and let me pass away naturally. If I have a heart attack, do not resuscitate. I know it can be an uncomfortable conversation. I get it. But it happens so often, and there's no document that lets the loved ones know what that person wanted to happen. And so it's really, really important to have these documents. I know some of us, even my parents, were really gun shy about doing this type of estate planning. And I said, listen, you really have to do this estate planning. You're making me look bad because I'm an estate planning attorney and you don't have your documents yet. But they just were uncomfortable having these conversations because they were a little superstitious, to be honest with you. They felt like by having these conversations that they were inviting the Grim Reaper to their front door. And I said, well, that's not how any of this works, because if that's how life works, then I would have had my $1 billion prayer a long time ago if it's just going to show up because I thought about it, right? So I finally encouraged them to do their planning, and the living will was, the toughest of them because they had to figure out, well, what does that mean? And how long do I want to be kept on the respirator and all of that stuff. But it's a great document to have as part of your overall estate plan so that the people who are left behind know what to do. I don't know if people remember the Terry Schiavo case. That was a case, goodness, at least a decade ago in Florida. Terry was pronounced by her doctors as brain dead, and they wanted to remove the life-sustaining tubes and all of that stuff. Her parents did not want the doctors to remove it. They wanted their daughter to just stay on life support indefinitely. Terry's husband, who was pretty estranged at that point because they were going through a divorce, said, no, she's not coming back. She's brain dead. Let's just let her pass away naturally. So there was a huge court case between Terry Schiavo's parents and Terry Schiavo's, who at the time was about to be her ex-husband when this accident happened, where he wanted to end life-sustaining measures and they wanted to keep it. And the reason it went all the way to the court was because there was no document whereby Terry laid out her instructions beforehand. So here you have parents who are fighting with pretty much a future ex-son-in-law, and they clearly had different opinions as to what was to happen. And if Terry had a document, that could have been avoided. So here's a quiz. My POA agent has access to all of my checking and savings account. Yes or no? Remember, we said that this is a very important and powerful document. My agent has access to all of my checking and savings accounts. Yes, great. Yes, yes, and yes. You are absolutely right. They do have access to all of those checking and savings account. And like I said earlier, if that makes you a tad uncomfortable, we can add some restrictions, but again, not too many restrictions where you would tie one hand behind their back. The other question I have here is, do you offer a package program where we can work with you to put together all these documents? Yes, absolutely. I try to make things as simple as possible, especially when it comes to basic estate planning. So if you want to have a conversation and say, I want all of these documents, I want the will, the trust, the POA, the healthcare proxy, and the living will, we'll bundle that into a basic estate planning kit, and it'll just be one flat fee for those documents. And of course, we'll do a review every few years to make any edits and changes that needs to be made to that document. Great question. Or you might say, I'm not ready for the whole kit right now. I think what I really just want is a will, or what I really just want is the healthcare proxy and the power of attorney. We can create those for flat fees as well. So thank you so much for that question. Someone wants to know who won the Terry Schiavo case. Her husband did, because even though they were going through a divorce, they weren't technically divorced yet. So he had the power. He was the person that the court deferred to, and he asked the doctors to remove all of the life-sustaining measures. And I don't think it was a week before she passed away. So that's how that case ended. And another thing that has come up before with respect to healthcare proxies, and I think I already mentioned this, is make sure that even though if you have one with your current doctor, that just applies to that one doctor. It doesn't apply to every situation in the state that you reside in. So that healthcare proxy that you sign at the doctor's office is not enough. It's not a full-blown plan. It's just good enough for that person. So here are some common mistakes that people make. So these are some freebies. Even if you don't go and create a document right now, these are some things you can take care of on your own. Titling. How you title your assets matter, because those assets will pass by law. Title is a legal title. So make sure that the property you own with anybody else, doesn't have to be a spouse. Maybe you and your sister own the townhouse together. Make sure it's titled jointly with rights of survivorship. Jointly with rights of survivorship. That means that when one person passes away, the other person automatically becomes 100% owner. No ifs, ands, or buts, no probate, nothing. It just trumps the contract and it trumps the will because it passes by law. Common mistake number 2, verbal understandings. This, I can't express enough how much death and money changes relationships. It changes things very quickly. So that understanding about, oh, my sister knows what to do. Oh, my spouse knows what to do. Oh, my child would never do that. Don't rely on any of that, because you have no idea of what is going to be happening when you are no longer here. You don't know if people will argue with each other. You don't know if all of a sudden random cousins come out of the side, out of nowhere. You don't know if your sister is so heartbroken that she can't even probate your estate and go down to the court and handle these things. You don't know. So try to make things as easy for those persons as possible by having something in writing. Outdated documents. I have clients who have gotten remarried and their will still mentions the first spouse. They've gotten remarried and their first spouse is still on their 401k plan. Go back in and renew your documents and renew your beneficiaries. Those things can easily pass by contract and they will skip the probate process. So if you have some freebies that don't need to get tangled up in the probate process, do that now. If you have a life insurance policy, for example, call your carrier, make sure the beneficiary is exactly who you want it to be, and make sure they're getting the amount that you want them to get. Another mistake is not using an estate attorney. I see so many people say, oh, I got a guy, he's my real estate attorney. He drafted a will really quickly for me. Or I went to LegalZoom.com and I got a will for myself. And if you're finding yourself in a dire emergency, like you wake up at 8 a.m. and by 8 p.m. for some reason you need a will, then I can understand going to those online software programs. But the reason I lean more towards an estate planning attorney is not just because I'm an attorney, but because you need someone who can keep up with the changes in law. You need someone that you can go back to and make changes. You might choose the right type of document when you go on, you might choose the wrong type of document when you go on and do it yourself. So having an estate planning attorney put together your documents is going to be really helpful, especially if that is the attorney you'll probably use for the probate process. So you want your executor to know who your attorney is so that when you die, your executor knows who to contact to help them go through the probate process. That's not something they should do on their own. That's something that an attorney should help them do. If you have an existing relationship with an attorney, especially the one who drafted the document, that's going to be so much easier than going through the yellow pages. I don't know why I say yellow pages. Yellow pages just doesn't even exist anymore. Going to Google and finding someone who can help you. No incapacity plan, meaning you don't have a power of attorney, you don't have a healthcare proxy. So when if you become incapacitated, there's no one who can step in and make decisions for you. At a time like this, where millions of people have found themselves affected by the COVID-19 virus, and hundreds of thousands have found themselves, well, they didn't find themselves, have unfortunately passed away. I'm sure there were some decisions that needed to be made by the bedside, and there was no legal document to address that. So if at the very least you do nothing or do one thing, have your incapacity documents created. And again, we can create that relatively quickly and easily for you. And then no life or disability insurance. Someone had a good question earlier about what if you have debt? Does that become the debt of your spouse? No, it becomes the debt of your estate. What's really helpful is having some type of insurance product, whether it's life insurance, that will pay that debt. Why is that important? I have clients who have these big, amazing dreams to leave their homes to their children, but the mortgage is super high, and the children say, we love this house, mom and dad, but we don't want to pay the mortgage. Well, what if mom and dad also left a life insurance policy that could pay the mortgage? Or what if you, as a business owner, know that you have $75,000 of debt in your business name? What if you had a life policy to cover that? So being able to have the right type of insurance product as part of your estate plan will make it easier as well. So just quick last minute solutions. Review your home title, add beneficiaries to your checking or savings account. That doesn't make that person the co-owner right away. They don't have access to your money. But what it does is allows that person to have access to your money relatively quickly at your passing. So for instance, let's say in my example before, I named Jai my power of attorney, but I also name her my executor. And one of the things I tell her is I'm going to name you as the beneficiary of my checking and savings account. What does that mean? When I die, Jai, you can go to Bank of America and take out money. Why would Jai need money right away? Because my utility bills still need to be paid. My mortgage still needs to be paid. Netflix wants it $7.99, right? And I don't want Jai to be in a situation where she's paying for those expenses out of her pocket. But if I can give her quick and easy access to my checking account, that'll make things easier for her. Because remember, the probate process is a process. It'll take some time before Jai can have access to my accounts. But if I can name her as the beneficiary on one of these accounts, she can at least start to take care of the more immediate pressing financial matters while the probate process happens. Contact your credit card companies to learn about what happens to your debt at death. Again, it does belong to your estate, but still reach out to your credit card company to see if they have some other type of unique process. And ask your healthcare provider for their healthcare proxy form. It's good for you to have, but again, it's not the end all and be all solution. So I just wanted to offer you all a discount if you decided you wanted to do planning going forward. I know it's not the easiest conversation to have, but I try to make it as easy and painless as possible. I'm really proud of you all for even considering it. And if you decided you want to move forward with the will, the power of attorney, the whole thing, no matter what you choose, I'm going to offer all of you on the line a 15% discount. All you have to do is email me in the subject line, I attended the Latinista webinar. That'll let me know that you're part of my Latinista family, and I'll be happy to give you a discount for that. I see another question in the chat. I'll answer that. What if there is property internationally? Assigning those assets have to pass the laws of that country, correct? Correct. So if you own property internationally, then we'd have to look into what are the laws of that particular jurisdiction. So maybe they don't have jointly with rights of survivorship. Maybe they call it something else. Whatever that something else, put that property in that name so that it passes by law in that particular jurisdiction. I will stop sharing my screen for a little bit so I can see everyone and check in with everyone here. I don't know, Jai, you're still there, right? Yes, she's still there. So if anyone has any questions, feel free to put them in the chat group so that I can see you and see your faces and all of the enthusiasm that you have. Oh, good. I'm glad you thought it was fascinating and helpful, Jasmine. That means a lot. Thank you so, so much. I love what I do, and my job is just to get you all information because, again, like I said at the top of the call, a lot of times we think that's, oh, that's for planning for those people over there in that tax bracket. And that's not true. It's for you right now in this tax bracket because you have assets and you have a right to dictate how those assets pass. I'm still looking at the chat group, so if it looks like I'm looking off away, I'm not. I'm just looking at the chat room for any questions you all may have. Thank you, Jessica. Really appreciate it. Really appreciate it. Your presence means a lot to both myself and Jai. I know Martha had to drop off, but thank you. Where can we find you online? Great, great, great. So a couple of places. I usually put quick informational videos on my Instagram page. It's Lillie_Nkenchor_PC. Hopefully Jai with her quick actions can put that in the chat. You can follow me there for information. You can also go to my website, which is lillieandkenchor.com. Schedule an appointment with me. Our first call can be 20 minutes. It doesn't have to be overwhelming, just to get an idea of what it is you're trying to accomplish. So you can find me at lillieandkenchor.com. You can find me on Instagram at Lillie_Nkenchor_PC. There's a YouTube page, Lillie and Nkenchor. I'm not hiding. So anytime you need something, feel free to reach out. And again, if the planning isn't for you, that's okay. Start to think about your parents. Remember, I had to wrestle my parents to their estate planning attorney's office to get them to put their documents together. If you find yourself in that situation, talk to your parents. Mom, dad, please just have a will. Because remember that your family is grieving you when you're not here. So now they have to grieve you and run around like crazy to get your estate in order. That's a lot. It's a lot. People don't realize that that is a lot. I have to come into this house and find your documents. I don't know where anything is. I don't know your checking accounts. I don't know your savings accounts. I don't know anything. Oh my God, I have to plan the funeral. Try to make it as easy as possible for the people who are left behind by having a document. And these basic documents go a very, very long way, as well as those assets that pass by law and by contract. Any more questions? Okay. You're so welcome, Mariana. I really appreciate you being here. And if you can't think of anything now, you make this sound so simple. It is. And that's the beauty of having an estate planning attorney, because I've been doing it, like I said, for 13 years, and I know the ins and outs, right? It's like, you know what it's like? It's like getting in an Uber car where the driver's like using the GPS and they're going the wrong way. And they're like, oh, I'm sorry, I'm just following. Whereas a real New York taxi cab driver who knows all the shortcuts will get you to your place faster. So consider me the real New York taxi cab driver, trying to make it as fast and as painless as possible. So that's a reason why you want to work with someone who has that skill. Otherwise, you have someone who's just looking at the GPS. And you don't want that, because you can look at the GPS on your own. Lillie is the driver. Yes, that'll be maybe I should make that my slogan, Jai. Lillie is the driver. Thank you all for being here. And if there's anything that comes up, again, Instagram and my website are where you can reach me at just about any time of the day. And like I said earlier, I'm really proud of you all for showing up here today. You did not have to, but you're here. So thank you so very much. And thank you to Latinista and Jai for even inviting me and holding such a great space for us to have these really important conversations. So thank you so much, Jai.